50% of Americans have a cell phone. The Supreme Court justices are taking a closer look today as to whether cell phones should be protected under the Fourth Amendment, or should the technology become fair game for the police after an arrest. San Diego criminal defense attorney Brian Watkins joins us to talk about these landmark cases that the justices are considering today. Brian, thanks for coming in.
Thank you.
The first case being argued today has ties to San Diego. So 4 years ago, David Riley, he was pulled over for having expired tags. What happened next?
Well, I understand that the officer searched his phone and found some incriminating evidence in his phone that linked him to a gang ties as also a murder, and he was subsequently convicted of that and received a sentence of 15 to life. The problem with this case is that what people don't understand is there's a lot of cases out there where people are stopped and pulled over and their cell phones are searched. No incriminating evidence is found. No cases are ever brought, and you never hear about those people. It's a good notion. A lot of people could say, well, hey, it's a good thing they caught a murderer because of that. But really, it violates everyone's rights, and everyone who's not committing a crime still has their privacy invaded when officers do that.
Yeah, police usually need a warrant before they search your home, so shouldn't they need a warrant before they search a phone?
Absolutely. You know, our office specializes in criminal defense, and we're leaders in protecting people's rights. And one of the most fundamental rights is that of your right to privacy. And searching through someone's phone is the equivalent of looking into someone's top dresser drawer in their bedroom. And that's very private. And that should not be done without a judge evaluating the circumstances and saying, yes, this needs to be done. It shouldn't be done by officers at their will on the street.
Who's subject to a cell phone search?
Anyone who gets arrested right now, they can pat you down. You have a cell phone in your pocket like most people do. They can go through your cell phone. I understand the pat-down searches. That's for officer safety, where they're going to look through your pockets, make sure you don't have a weapon, maybe, you know, look to see if you have any drugs. They can even go through your wallet. But when you're going into someone's cell phone, you're actually entering into different applications and different files on their phone. It's a lot different than patting down someone's pockets. Like I said, I would akin it to looking through the top dresser of someone's drawer in their bedroom. And I think that if anybody had their top dresser drawer searched through, they'd feel very violated.
And let's say you're jaywalking. What's the legal reasoning an officer has for searching your cell phone at that point?
Well, I don't know if they can do it for jaywalking, because that's not an arrestable offense. But any other minor traffic violations, such as driving on a suspended license, where you can be technically arrested for, then you can have your cell phone searched subject to that arrest. And they can be phishing, and that's what officers do in a lot of cases. They pull people over that they suspect are doing things. They don't have any real evidence that they're doing these crimes. They'll pull them over for a minor traffic violation and basically start a phishing expedition, and that's what should be curbed.
There's so much sensitive information on smartphones that's private these days. How far can officers go when they're looking through your phone?
And that's a good question, and basically they can look through your phone. What does looking through your phone mean? It looks through everything that's in your phone, and that's where the law needs to catch up with technology. It's not like I'm just checking your recent calls. Within your smartphone today, you got your bank records, you got medical records, you got intimate photos and videos and things like that. And that's what I'm hoping the Supreme Court will curb in saying, hey, this is more than just a search of someone's phone. This is a search of their private lives, all contained inside their phone.
But in this day and age, do you think some people are willing to trade some privacy for security?
Well, of course, in today's society, in this post-9/11 world, yeah, we've traded a lot of freedoms for perceived safety. But the key here is that you can still search the phone. What we're only asking is that let a judge make a determination that this needs to be done. They can seize the phone, hold the phone, get a search warrant, and still search that phone. It's not like we're saying that this is going to completely absolve one area of police investigation. I mean, the phone is still there. It can still be searched. It just needs to have the proper procedures done prior to that.
Now, we won't find out what the justices will decide until this summer. What are your thoughts on what their conclusion will be?
I'm hoping that the justices have the law catch up with technology, and I hope they realize that searching through a cell phone is not the same as patting down someone's pockets, but it contains a lot of private and intimate information that would need to be, you need to obtain a warrant in order to go through that, just like you would need a warrant to search through someone's top dresser drawer in their bedroom.
Well, thank you so much, Brian Watkins, for coming in to us and talking to us. No one's immune from getting arrested, so essentially if you have a cell phone, this affects all of us.
Thank you.